I'm Justin Silverman of the New England First Amendment Coalition. Thank you for joining us for this introduction to open meeting law, our latest round of video tutorials and other lessons on freedom of information laws in New England. If you haven't already, please check out our previous lessons on public record laws and the Federal Freedom of Information Act. All lessons are available to view at nefac.org/FOI guide. In addition to more video tutorials, you'll also find there other helpful resources such as common Q&As, notable case law, and an FOI legislation tracker. This round of lessons is brought to you by NEFAC with help from the Society of Professional Journalists Foundation, the Rhode Island Foundation, MuckRock, SPJ New England, and the New England Society of News Editors. We're grateful for everyone's support. Thank you. Now, here's NEFAC's Emily Sweeney to introduce you to your instructor.
Hey everybody, I'm Emily Sweeney from the Boston Globe, and I want to thank you all for joining us for this webinar, which is part of our ongoing series on freedom of information laws. This session is going to focus on the open meeting law in Rhode Island. And with us today is Raymond Marcaccio. He's the co-founder of Olivero and Marcaccio LLP, and he represents local news media organizations and brings claims for access to public records and court and government proceedings. So he knows this law inside and out. Ray, thank you so much for walking us through this.
My pleasure, Emily. Hi, everybody. I just want to go through this and give you kind of the nuts and bolts of the Rhode Island version of the Open Meetings Act, and just give you a summary of each of the statutory components, and then just give you just a few observations. I know this is kind of a basic explanation or for that purpose. So, and I'll follow that idea of just giving you kind of the basic information. Let's see here. When I think of the Open Meetings Act, I think of really two components that we focus on, and that is both the meeting itself as well as the notice. So the requirements that we have for both what constitutes a meeting as well as what the agenda should look like. Those are two areas that the statute focuses on, and I think the public interest would focus on as well. The OMA, the Open Meetings Act, is quite broad as to its application. So the statute reads that any department, agency, commission, committee, board, council, bureau, or authority, or any subdivision thereof, or state or municipal government is considered a public body and covered by the OMA. So that would even include, for example, if you had a public body that would be charging a subgroup or creating another committee of other public people from the community. If that subgroup, that subcommittee, for example, has a charge from the board or the public body itself and reports to the public body so that the body itself can make determinations, that subset likewise would be covered by all of the applications, all of the statutory components of the Open Meetings Act. So a meeting, I think we all know what that is, but the statute has a very specific definition as well. It's the convening of a public body to discuss and or act upon a matter over which the public body has supervision, control, jurisdiction, or advisory power. So you could have a meeting that takes place of a public body, the members themselves, where they don't talk about any of that. They could be meeting at a bar, for example. And if they're talking about the weather, well, that's not going to be considered a meeting. By the same token, if they met, even in that forum, and started to talk about a matter over which they have supervision, control, or jurisdiction, even though they thought they were just mentioning the passing, they're actually triggering the requirements of the Open Meetings Act and the requirements that are set forth for holding a meeting. Those meetings must be in person. There are only a few exceptions. So if you have someone who wants to participate by phone, for example, because they might be on vacation, they're not allowed to. The only way that you can do so is in person, unless you are in the armed services on active duty, or if you have a disability that restricts you from participating. And for disabilities, that can be something that would be addressed, I think it's by the Disabilities Commission. So they would actually, if there is some determination that you can't show up and attend in person because of a condition that would be legally deemed to be a disability, then though that subset of people, those public members, could participate in those limited circumstances by video or by phone. So the statute indicates you must be physically present for the meeting, unless you go through one of those exceptions. And for the public, you likewise have the right to be in attendance. When the meeting is held, it needs to be held in a place, in a forum, that allows you to observe the proceedings themselves. You should be able to hear everything. You should have easy access to the meeting itself. There should be no physical barriers or any other barriers to your attendance and your ability to hear the proceedings. And then you get into exactly what is that public body. When are the requirements of the Open Meetings Act triggered? That is triggered whenever there is a quorum present. And a quorum under the statute is a simple majority. It's not a supermajority, it's just a simple majority. So if you have a 7-member public body, if you have 4 members present, you now have a quorum. If you have a quorum, and again, you're at the bar, and you start to discuss matters over which you have oversight, governance, you've now triggered the requirements of the Open Meetings Act. So it's important to make sure that people who are in a quorum limit their discussions, their business, to only those times they are in a posted meeting with a posted agenda. Sometimes public bodies can trigger a quorum when they don't even realize that they are, because a quorum can be triggered even if you're not physically present with a majority in the room. So, for example, you could have what's considered a rolling quorum, where you have 2 members, not 4, but you have just 2 members. They're sitting together and they start to discuss a matter over which their public body has governance and control. One of those members conveys to another person at another meeting the contents of what just occurred in that first meeting. You now have the beginnings of a discussion that is rolling from one limited group to another limited group, and it can then continue. If it continues and exceeds the number of public body members that constitute that body's quorum, then you actually have created a quorum, even though you didn't have everybody physically in one place at one time. And that is a classic rolling quorum obligation. It can be done in another way as well. If you have a relay by someone who's not even on the public body itself. You could have someone who is on the staff of that public body listen to information from one board member, convey it to another, get that person's input and consent, convey it to another, get that person's input and consent, convey it to a fourth, and again, get that person's consent. You now, through a third party, with just one board member there and the rest just being staff, created a rolling quorum. Any of those circumstances I just described would be a violation of the Open Meetings Act. So those are things that public bodies need to be aware of, and you in covering it should likewise be aware of that as well. Now, it's possible, I think, that a public body could even create that kind of a rolling quorum issue or prohibited communication issue by the use of emails. So if you had, for example, a body that was receiving emails and conveying emails to talk about public business, and at the end of that discussion through those emails, there is a consent, there is consensus reached. Arguably, you've had two-way emails discussing public business by email and then basically coming to an agreement. That is a violation, or can be a violation, of the Open Meetings Act. Now, it's very different if you just have information being conveyed in one direction. Really, there's no consensus that can be developed by the board members because they're just receiving an email that says, you know, here's information that will be discussed at the next week's meeting. The documents will be addressed in agenda items 2 and 3, et cetera. That kind of a one-way distribution of information to the board member, to the public body member, that normally would not be a violation because it's not an attempt to have some kind of a consensus reached by email or some other form of electronic communication. Just a point about what's occurred since COVID. We all know that for some period we had the added benefit, at least some thought of it as an added benefit, of having the ability to observe the public body remotely by live streaming the meeting, so that people could at least observe, and sometimes actually even when we were in COVID, fully participate in the meeting. The public members likewise could. And that was all through executive order, where the governor of our state, and I'm sure in many states, lifted the requirements of the statutes that require you to be in person and bypassed that and allowed you to participate in all manner, even gathering evidence and hearing information and reviewing documents, all remotely because of the crisis that we have with COVID. That has completely stopped. So all of the executive orders that allowed for public bodies to participate and hold the hearing completely by video, all of those exceptions have now been terminated. What we have instead is the option for public bodies to live stream their meetings. And that would allow people to at least observe the goings on of the government. That is not for the actual public members. You can never create a quorum of your public body by having one person viewing it by live stream and the other 3 present physically. You have to have 4 people present. So the public members are not allowed to participate remotely. And I'm looking at this, some of the language here where it says you may permit members of the public, and that would just be for the members, not for the actual people who are the public body members. So you can at least participate remotely by viewing it. And that would require that you have the ability to hear and observe everything that takes place. So if you do have a meeting that's taking place, physically taking place now, that's the requirement, but that body is actually live streaming it. In all likelihood, in my opinion, I think it's the statutes would require that if there is a termination of the remote participation, then you would have to actually terminate that meeting. And I'm thinking actually that applied more when we were under the COVID remote setting. Here, it's not as clear that if the public can observe it and then suddenly that remote connection is dropped, I'm not sure that you have to cease the meeting, but that has not been made clear, but that could be a possibility. So those are some of the requirements for the public meetings. And that all has to be done in open session. And it has to be observable. If you're there or if you're not, you should be able to hear it and you should be able to see all aspects of it. There should be no subset discussions taking place, whispering or anything. This is all to be heard by the public. Things are, of course, very different if it's an executive session. And that's when the board has the right by statute to basically close the door and to deliberate and in some cases vote, but mostly deliberate or discuss matters that by statute are exempt from public disclosure. If that takes place, before that can take place, the board needs to vote expressly why it is going to meet in executive session. It needs to cite the statutory reference that allows it to meet in executive session. I'll show you some of those type of topics that can be done. And only upon an express vote can it then convene the executive session. So as I just said, you have to actually specify each item that needs to be discussed. So if it's a matter, as I say, on, for example, job performance, or if there's going to be some discussion about the physical or mental health of an affected person. In those circumstances, for example, the board can vote to restrict and close the meeting, specify that it's going to be for a discussion on job performance, and then go into executive session. I don't know how much interest you may have on this, but before they do so, just so you know, the person who will be discussed, so if you have an employee and that employee is going to have their job performance discussed, they have the right, there's an obligation that they receive written notice that there will be a meeting to discuss their job performance. And that is actually something you're supposed to say on the record. So before you go into executive session, in addition to everything else I just said that you have to say in your motion, you also have to note for the record that they received that written notice. And that person has the right to waive the confidentiality of that meeting. I haven't seen that done, but I'm sure there are occasions when the person wants to actually hear what's going to be said and therefore waives the right that it be done in executive session, forcing the public body to then meet in open session. Because if it is just to talk about your own job performance, you actually control whether the doors are closed or not. Now, and I have some other examples here, but before I get into them, it's just important to note that the executive session is for the public body itself. And the public body has the right to invite whomever it wishes to bring into the executive session. So it's not automatic that you have the right to be in there. It's something you would be receiving by invitation. Obviously, if it's to talk about job performance, many times the public bodies will actually hear from that person, to hear their side of what's going on with performance, because for whatever reason, the board is getting involved in it. But it is by invite that you go into the executive session, not by right. So if you are seeking to make sure you hear everything and you're the subject of it, you protect yourself by waiving the confidentiality, forcing the board to come out in an open session. Like I said, it doesn't happen that often. I cannot remember the last time I've seen that happen. Other examples, just to move along with some of these, collective bargaining. Obviously, that's something that the public body has a right to discuss in executive session so that they can come up with their own strategy for dealing with their negotiations. Any litigation, any anticipated litigation, that likewise can be a subject for an executive session. Bear in mind that if you're sitting in the audience and they're talking about litigation, it's the requirement of the public body to actually identify what will be discussed if it's already known to the public. So if you have a public body that has been sued, then that's a matter of public record. And there's no reason why the public body shouldn't be saying that they should be identifying, we hereby vote to meet an executive session to discuss litigation identified as John Doe versus us, public body. Identify it, I think, with a lot of specificity, even the court that it might be pending in. That's an obligation that the public body has to make sure that you know what's being discussed. If it's anticipated litigation, and by disclosing it, you might affect your own rights as a body, you don't have to identify who might be suing you. Other reasons they can meet an executive session, they want to conduct or commence an investigative proceeding, whether it's civil or criminal. They have the right to have that discussion in executive session to hear from those, for example, who are conducting the investigation on their behalf. The school committees have their own eccentricities under the Open Meetings Act, and I don't think it's needed for me to go through those. There are several, but certainly one of them that generally, the school committee, if it's going to be discussing anything on a student, disciplinary hearings, anything that might affect their privacy, including their own student records, obviously, that would be something that could be discussed in executive session. And as I said, and as I say here by reference to the statute, it's the public body that can invite someone into that session. The other aspect that I think is pretty important is what the public notice needs to be. So obviously we have time constraints of 48 hours for giving notice of an actual meeting, the specific meeting. That's 48 hours. That would be 2 business days. Up until recently, that used to be 2 days. And there were public bodies that might post publicly their agenda for Monday on a Friday afternoon. And under some people's interpretation, that was allowed. So some entities did that. I don't know if it was common or not, but that was something that the General Assembly addressed several years ago, and it's clear now. You need to give 2 full business days notice of any actual meeting that you're about to have. And I think one of the most important things, and this may be the last thing we speak about, is the, at least in detail, that is the specificity of the agenda. I think that is the area that, as lawyers, there's a lot of concern for what the agenda, how it reads, for public interest groups and for people covering the business of government. This is so important to know that the agenda needs to have a degree of specificity sufficient so that the public knows what's going to be discussed. The days of being able to say that you're going to get a report from the executive director and that's it are gone. The days of just being able to say, you know, new business, old business, something is general. Those, and sometimes it still happens, but those days are gone. The courts look to see, the Attorney General looks to make sure that you as a member of the public can read that the four corners of that document, the agenda, put it down and know what's going to be discussed with enough specificity so that you can decide whether or not you want to attend. And if you diverge from that and you have something so vague that people don't know, when you talk about your fiscal budget for the next quarter, that's okay. But if in that fiscal budget you actually insert the introduction of an entirely new program that requires the board to hear about a new program, take a separate vote on a new program, take a separate vote on funding a new program, all of that should be done in a way so the public knew that that program was going to be discussed. Sure, it's a subset of your budget, but it should be done in a way so the public knows it's that program that will be discussed, and it should be specified in the notice itself. If it isn't, I think there's a ground for finding that is an inadequate agenda. And what's the remedy for that? If the Attorney General received a complaint, it's likely the Attorney General would find that any vote taken is void. That you need to reconvene that meeting with the right kind of agenda posted with specificity, and then hear it again so that the public can observe what its government is doing. Amending the agenda is something that can be done. I don't know how often it's done. I mean, I know it's done, but I don't know if it's routine. I don't think it is. But if it is amended, it should only be for the purpose of a discussion item. It cannot be for the purpose of adding something in within that 48 hours to the agenda that requires an action by that public body. That would not be allowed. That would not be allowed. There is an exception to that. And that is if there is a need for that public body to take an action to protect the public. Could be a matter of health. It could be a matter of voting rights. It could be something of major significance to the public to protect a public's fundamental right. If so, the courts, and I believe the Attorney General, would find that amending the agenda within that 48 hours or whenever as soon as you can would be permitted. But it is extremely rare that a matter rises to the level of protecting the public to the point where you need to bypass the normal 48 hours. It is an unusual circumstance. Almost, it's just, as I said, rare that you'd have something of that urgency, but it does happen, especially in times of COVID. If I can think of one where the Board of Elections was told that there was a packet that had just been dropped in a polling place with a white powdery substance, and they needed to close down the polling place and create an entirely new place for people to vote. That was all done on a rapid emergency basis within hours, minutes really. And that was to make sure that the health of those people were protected, even though it ended up being nothing of ultimately where people's lives were in jeopardy. But that gives you a sense of how unusual it would be, though. It would have to be of that type of extreme circumstance. As I say, and this is now citing the statute, it's going to require, at the top here you can see, immediate action to protect the public. And you can imagine how infrequently that would happen with most public bodies. Public comments. That those public comments can be allowed, but you cannot take a vote on a comment that has been raised by the public. I'm trying to move on here because I see, Emily, that we're kind of short on time, but I just want to touch on this, and that is, I'm sure that there are times when you make requests for minutes, and there may be times you're surprised at what's in it, because really by statute at least, the minutes have to have what I would describe as bare bone information. They need to say who was present, when the meeting was convened, where it occurred, and then it should note what the motion was and what the votes were. As far as getting into a detail of who said what, that isn't required. And you can imagine, especially with smaller public bodies, that might be a certain burden to have to create a long narrative on what's occurred. But I have seen that done, where public bodies can go on for pages setting forth details of what everyone said in the meeting. But that isn't, and while that's great, that isn't something that is required by the statute. If you do go and you want to make sure that you record everything, you have every right to. It's a public meeting. No one can stop you from recording it. No one can stop you from videotaping it, so long as you don't in some way disrupt the proceedings. So, that's the only limitation. Finally, just so you know, complaints, those normally do go to the Attorney General. The public likewise has a right to file them separately in Superior Court. But I have found, especially, in recent times, in my view, we have a Attorney General who's very interested in matters of the public, and those are taken, I think, seriously. So they do have to be filed within 180 days from the time of the minutes have been approved. If there were no minutes, or if the meeting was done, in your view, at a bar and was never even posted, it should be done within 180 days from the time that that body acted without the proper notice. I think that's it as far as giving you the nuts and bolts of the Open Meetings Act.
Yeah, Ray, thank you so much for a great overview. And thanks everybody for tuning in, and be sure to catch more episodes. Thanks,
Thank you.
everybody.
Take care.